I'm Les Wilkinson with the law firm of Wilkinson Magruder. I'm here with Andy Magruder, my law partner, to talk about Social Security disability. We're your local attorneys for Social Security disability in the Augusta, basically Aiken, South Carolina area. And so we're here to answer a number of questions which have come up. We hope you find that this YouTube presentation is interesting.
Les, we're always asked, well, attorneys are expensive. I've not worked in 3 years. How can I afford to pay for your legal fees?
Well, Andy, for Social Security disability claimants, as well as for folks with SSI problems, that's probably the best part of the system. Social Security has to approve any fee between an attorney and a claimant in a Social Security matter. And a lawyer doesn't get paid unless the client wins. If the client doesn't win, they don't owe the lawyer anything for his time. Now, our fee agreements, they're pretty standard nationwide, provide for an award of attorney's fees of 25% of your past due benefits up to $6,000 at the initial level. In other words, at the hearing level, if your past due benefits are $30,000, our fee's $6,000. If your past due benefits are $1,000, our fee's 25% of that. And so that's the best part. If the client doesn't win, if you don't win your case, you don't owe us anything. So it doesn't cost you anything to come see us. We don't charge for initial consultations. We don't charge for phone calls. Some lawyers, you call them up and they send you a bill, but we don't do that. That's a part of our whole service we render as representing folks with disabilities. That's one of the services we don't mind providing. But getting back to attorney's fees, now if you win at the initial level, in the hearing level, the maximum amount of attorney's fees is $6,000. Now that can, if you go to the appeals council or the federal court, the fee agreement changes, it still cannot exceed 25% of your past due benefits. And if you go to federal court and you win, then you're allowed to ask the court to award you what they call EJA fees, which is Equal Access to Justice Act fees, that are basically awarded against the government because they were stubborn and didn't find you disabled from the get-go.
But the bottom line is when a client comes to see you, they don't have to give you a retainer, they don't have to write a check, they don't have to mortgage their house. They just, or their second child.
Not usually now.
No. It's all done on a contingency fee basis. Is that correct?
That's right. It's all contingency. If you don't win, you don't owe us anything. And that's the best deal. But if you win, our fees maxed out at 25% of your past due benefits.
Thanks for watching us on YouTube. I hope we answered your questions today.
We're Wilkinson and Magruder. We're located in Augusta. Give us a call. Let us help you.